of Carelink in circumstances where he performed a role in respect of offenders professionally as well as a role in relation to Carelink?
I certainly was of the view that he was an eminent psychiatrist. The Archbishop had a great respect for him. He was a very skilled person. Ultimately, the decision was made that he was a very skilled person. Ultimately, the decision later, I was involved, I think, in getting Dr. Michael Schwartz to provide a report on Emma, because I believe very strongly that, you know, someone who's treated victims should not have a treating role with. I've got it wrong. That someone who was treating offenders should not have a treating role with victims.
Well, perhaps if we can just have tab 140 on the screen, tab 4 on the screen. Just have tab 140 on the screen, tab 4 on the screen. And if we can scroll down to the second page, and you can see there that the first responsibility is to act as the public face for clinical services provided to, and you can see there that the first responsibility is to act as the public face for clinical services. Scroll down to the second page, and then if we can scroll down to the second page, and to see the signature. That was your letter as Vicar General.
That's right.
Archbishop, and the paragraph in full that's on the screen, it's noted that from time to time you provide treatment to priests of the Archdiocese, and obviously you will not have direct contact with persons who claim to be victims of such priests, but with that proviso, no conflict of interest is perceived with your role as the support professional.
Correct, and that was my understanding.
Now, did you see it not so much as a conflict of interest? Did you see it from the perspective of the victims as to how they might perceive the public face of Carelink being a person who provided treatment to priests of the Archdiocese?
From my other life, I would have had it very clearly in mind that if a person has a relationship with an offender, they shouldn't have a relationship with the victim. The decision was made for right or for wrong, and I think I would be a lot more compassionate now, was that Ball was the appropriate person to head the service, but he didn't ever, apart from an initial meeting, that Ball was the appropriate person to head the service, but he didn't ever, apart from an initial meeting, he didn't have to have any treatment or other dealing with.
Whether he had been engaged with an offender, be it by way of treatment or providing a report to the courts in respect of somebody who was before Carelink for Carelink's attention.
I would have expected of a member of the medical profession that he would recall these things.
Was there anything that you now recall put in place to ensure that he either recorded or advised those at Carelink as to people from time to time who he had or did either treat or report to court about?
No, I don't recall anything being put in place.
Archbishop, you understand it's a perception problem.
Oh, absolutely. Absolutely.
And as soon as someone, and with great respect to the professor in his professional position, publicly is publicly identified with the victim in that way, the perception is irretrievably fixed, isn't it?
I know that and I understand that.
Why wasn't it understood back then?
Well, I understand that.
Why wasn't it understood back then?
It's not a cop-out, but I didn't ultimately appoint Professor Ball, although I wrote the letter.
You didn't
it was
stand
the
in the way.
Archbishop's decision.
You didn't stand in the way of his appointment, did you, Archbishop?
No. I think because the consideration was that he was the most experienced and best qualified. I think with the benefit of hindsight, I'd certainly consider more carefully.
Well, again, going forward and with the Royal Commission's task front of it in relation to redress, you wouldn't suggest, would you, that if there was any counselling or medical component as part of a scheme, that the public face would be a person who treated offenders or provided reports in respect of those offenders? And that's not a matter that's at all got to do with Professor Ball's integrity. You understand that? It's a matter of perception, not integrity.
Correct.
Now, can I come then to the litigation? You became aware that the Fosters, that is Mr and Mrs Foster, and on behalf of their children, had commenced civil proceedings in respect of a number of people identified within the church.
Correct.
And that Richard, leader of cause, was the solicitor that was effectively appointed to act in respect of each of the defendants.
And that's correct.
And he'd been advising the Archdiocese as a partner, and then prior to that in associate roles for some time.
Yes.
And in fact, he had been handling probably all of your sexual abuse cases up to that point. Is that a fair comment?
From the time of the beginning of the Melbourne response, certainly. He began advising the Archbishop from about August 1996.
You're aware that Mr Leader's given evidence?
Correct.
And he has given evidence in relation to the instructions he initially obtained from you in relation to the defence of those actions?
I'm aware of his evidence.
In more general terms?
In more general terms.
There is a file note of his, and I can take you to it if you need to, of his discussion.
It's in the front of the mind.
His discussion with you, Archbishop, and he's given evidence about that, in which he records the instructions you gave him as to take the defences.
My total mind, I was deeply conscious by this stage of how much the Fosters had suffered, and I understood why they wanted to go to litigation. My total mind was they wanted the matter to be settled, and to be settled as quickly as possible and with as little difficulty as possible. While I don't have specific recall of the specific telephone call, if Richard Leader put a note in his file, that is correct.
But you understand...
I would have...
oh, certainly. I'm sorry, I didn't mean to interrupt.
I would have read the statement of claim, and I would have noticed that some of the matters in the statement of claim were not, I thought, correct, such as naming the trust corporation and things like that. And I remember a discussion with Richard, trust corporation and things like that. And I remember a discussion with Richard, been long-standing, would do whatever is necessary to carry the matter forward. Our solicitors, who'd been long-standing, would do whatever is necessary to carry the matter forward. Now, I don't recall any discussions of detail. I'm sorry, I can't refine it any more than that.
No, but you understood, didn't you, and your lawyer would have told you, that it was a choice for you as a defendant in those proceedings to decide how and whether you would as a defendant in those proceedings to decide how and whether you would defend them. You understood that?
I would have understood that a statement of claims had been made, and that because matters were entering the legal sphere, that the normal action would be taken by our lawyers.
Well, when you said whether the church or you as a defendant would respond to that statement of claim, you're aware of that? I would have
listened carefully to...
Respond to that statement of claim. You're aware of that?
I would have listened carefully to what Richard told me, the detail of which I don't recall, and I would have agreed that the lawyers should proceed in what I understood as the normal way.
So, as we should understand it,
Yeah.
you effectively gave instructions to Mr. Leader that he should take whatever defence. Were you conscious at that stage that there were multiple issues involved in such a defence? Starting off with, can any identifiable body or person be sued? Did you understand that there were multiple...
I think I wouldn't have gone into, with respect, the legal technicalities, but I knew there were a number of issues, and I trusted my lawyers to do what they felt they should.
One of the issues you now know that is involved is what's referred to as the Ellis defence. You understand that?
That was certainly not discussed by us.
No. But you're aware of it now?
Yes.
Yes. And another issue is the issue of vicarious liability. Were you aware of that then?
Not specifically, no.
Right.
You deal with this in your statement at paragraphs 167 and some preceding and after that. Perhaps we can have that on the screen. Paragraphs 167 and some preceding and after that. Now, you say that in paragraph 167 you were dependent upon your legal advisors. However, your recollection is that your lay reading of the statements of claim, assisted by that legal advice, suggested that the claims seemed to be alleging that the defendants, such as yourself personally and the Trust Corporation, were legally liable for the crimes committed by O'Donnell, which didn't seem to you to be right. Can I suggest to you, Archbishop, that a lay reading of those statements of claim by you in circumstances where you had accepted moral responsibility in respect of those crimes, and indeed you had offered, in relation to Emma, an amount of money, that is the full amount that was available to her under your scheme. Can I suggest that a lay reading would have produced in you, rather than that it didn't seem right, that in fact it was completely right, what they were saying?
What a ridiculous question.
Well, that was the way I think I understood it. I
It's
can't
not-
really elaborate on that.
I beg your pardon?
I can't really elaborate on that. I understood that for them to be proposing that I was personally responsible or that the Trust Corporation was responsible, that really didn't seem right to me. That's...
Archbishop, in paragraph 169,
Yeah.
you say you were conscious of the heavy burden of responsibility. Paragraph 169, you say you were conscious of the heavy burden that what Ms Vanessa just put to you, and what you've said in paragraph 169 raises an obvious conflict. You say the Church had a heavy burden of responsibility. Now, if it has that responsibility, then it's a responsibility shared by the Church, including you as the Archbishop and I assume the whole of the congregation.
I think I was desirous, I had one desire, and that was that the matter would be...
Archbishop and I assume the whole of the congregation.
I think I was desirous, I had one desire, and that was that the matter would be settled. I understood that the Fosters had taken the view that because of the tremendous burdens, both past, present and future, that they needed to...
Report of the Parliamentary Committee here in Victoria.
Yes, yes.
And the recommendation that the Church create a corporation which is capable of being sued, thereby removing the Ellis defence. Do you understand that?
Yes, Your Honour. May I go on?
Yes.
We've also recommended to the Victorian Government, and we've recommended in our Truth, Justice and Healing submission, that throughout the Church, not only in Victoria, but throughout Australia, that the Church provide an entity to sue, and also that the removal or increasing of the time of limitations would be made.
Thank you. You've anticipated my question. Now, if you'd held that view back when you were having these discussions with Mr. Leader, you would have told him not to take at least that part of the defence, wouldn't you?
I think I would have to say yes.
Indeed, if we turn to 169, you indicate there that your strong preference was that their claims be resolved without delay, pastorally and in a non-adversarial way, if that were possible. Do you see that?
Yes.
Now, that could well have been achieved by not filing any defences and seeking to enter into some mediation process on receipt of the statements of claim.
I must have to say that that was not a matter that was discussed at the time.
It's not a matter that you raised?
No.
It's not a matter that was raised by your lawyers with you?
Not that I recall, simply.
Having been through that experience with the Foster's litigation, Archbishop, are there any changes you would make now to your response were you to receive a writ tomorrow in which you were one of a number of defendants?
I mean, I think I would address particularly that matter that I discussed with His Honour, the whole question of making sure that there was an entity to sue and considering much more carefully in the matter of the statement of claims, matters that would be less hurtful to people.
Can you tell us, Archbishop, when it was that the view you've just expressed was a view that you first held? Can I assist by giving you some time frames? The defences were served in the litigation in October 2004, and some time frames. The defences were served in the litigation in October 2004, if that assists you with when you first held the view you've just given evidence of.
I think it would have been subsequently to that, particularly when looking to the Victorian inquiry, what are the consequences, what are the possible way forward. It might only have been at that time, really.
So 2012, 2013?
Yes.
Thank you. Your Honour, I note the time I will be a little while longer.
Yes, just one question before we break, Archbishop. And I should preface this by saying that no one should assume that I or any commissioner has any concluded view on any of these issues. That's often been misunderstood, I think. But your paragraph 169 raises, of course, the issue which lawyers speak of as vicarious liability. I firstly ask, are you aware of the Supreme Court's in England's attitude to the liability of the church or a church body when a child is abused by a member of clergy or other religions?
I'm certainly aware. Was it the Diocese of Portsmouth?
Yeah.
I'm certainly aware vaguely of that decision.
What it puts into the legal domain is the liability in a body such as the church when a child is entrusted to its care, be it a school, be it the church. When a child is entrusted to its care, be it a school, whatever, when the parent entrusts the child to the church, the boy, whatever, when the parent entrusts the child to the church, the ability for the actions of any of its members or other officers who have legal responsibility for the actions of any of its members or other officers who perform the church's function, irrespective of whether...
I understand this discussion, Your Honour. I think it comes back to the nature of the church. People enter the church not just back to the nature of the church. People are members of the church normally through baptism, and that establishes a familial relationship with each other. But the relationship between a bishop and a priest is that the priest is not just employed to do certain things, but is the holder of the office which he exercises freely and intelligently in terms with what's in the scriptures, what's in the catechism of the Catholic Church, what's in our law, what's in our doctrine, social doctrine and so on. And he is expected in his parish to act in accordance with those. So it's a broader relationship with the church rather than and a familial type of relationship rather than a specific employment relationship with the bishop. And therefore in this diocese, with its 216 parishes, the basic matters of prayer and liturgy and caring for the sick and visiting the elderly and running the school, they were all done in a basic way, but there's no limitation to other initiatives that people can take at local level, priest and people together. So there's considerable freedom, and it's a broader kind of relationship than you would require of someone working in an office who has certain hours and certain duties.
I understand that, but the fact that the parish exists at all is a product of there being the church, isn't it?
Which is people and clergy as well.
That's right.
So we're all in it together.
And it's one institution, even though it has component parts. And the argument that's put is, well, if you've created that institution within which the offer is made, if you like, to the parent, bring your child, you can trust your child in our institution, and the institution fails, that there should be an institutional response.
Does the institution fail, or does the person fail in his responsibility to the people and to the institution? So we both failed.
Well, even if you both fail, the law may, and the English have gone down this path, say that the institution carries the burden of a response. Do you understand?
I think, obviously, leaving aside questions of knowledge and prior knowledge and all that sort of thing, leaving that aside, I still think that our relationships in the church, I hope, are of a higher order, and I hope, therefore, that our responsibilities are of that higher order too. It gives me no joy whatever when these criminals do these awful things, and that's why I've always been, this is a side comment, been very quick to act, because the protection of children is the absolute top priority.
We'll come back to these difficult matters tomorrow. I think
Thank you, Your Honour.
Your Honour, just before Your Honour adjourns, Mardo inquires to the materials that were sought from Mr O'Callaghan last Tuesday.
yes.
I can indicate to the Commissioners that I have instructions that Mr O'Callaghan signing a letter to the solicitor assisting the Commissioners at the moment, which addresses the answers to all but one question, and that question he'll endeavour to answer overnight. And the only remaining question is one that was asked of him in relation to, in respect of contested hearings, the percentages of those who appeared with representatives who Mr O'Callaghan paid for and then got reimbursed, and the percentage that that didn't pay. So he'll answer that one overnight.
Very well, thank you. 10 o'clock in the morning.
Thank you.